Hello, this is Zach Kinnaird. I'm here with Baba, the president of BLSA.
Baba here.
That's the Black Law Student Association. This is a very special vlog, or at least the first of what might be many, as it's not an overview of the week, but more of a student organization's update of what's going on. And what's going on is a Fisher versus University of Texas case, which touches on affirmative action. Specifically, in the state of Texas, they have a particular admissions program after the Grutter case, which was a Supreme Court case which disallowed schools from using race as the predominant factor. The University of Texas came up with a new type of admissions program called the Top 10%. I actually went to the University of Texas and was admitted outside of the top 10%, so I sort of know how this interplays. They take the top 10% of every high school based on GPA class rank, and they are automatically admitted to any public school in the state, public university. This, for the University of Texas, became a problem in 2008 when the number of applicants who would be automatically admitted would surpass the amount that the school could actually hold. So the state legislature passed a cap which limited that number to 75% of the incoming class. What this results in is that the university has its say over the remaining 25%, while the other 75% are automatically admitted. Now, Ms. Fisher is a young white female who was denied admission to the University of Texas as she was not in the top 10% of her high school class. Her argument is under an equal protection argument, stating that those who were admitted under special circumstances, whether it be race or any other protected class, was denying her a spot, even though they may have been less qualified based on simply grades alone. The university, on the other hand, is reserving that 25% to approach admissions a more holistic way, to look at not just GPA, but also a separate category of special circumstances, which could include race, socioeconomic status, geographic location, those sorts of things, including leadership qualifications. So in that sense, this is the university's argument. Now, we're going to go to Baba to talk about what is BLSA's standpoint on this.
BLSA's stance is any stance that increases diversity in the legal education, but it starts with the undergraduate education, and that's the pipeline into getting into law school. Getting into better undergraduate programs leads to getting into better graduate school and professional school programs, which leads to better jobs in general.
And Baba, what is there anything specifically that BLSA is doing to get ready or to increase awareness of not just affirmative action but also this case?
BLSA is actually having a social media outreach that they're doing from October 8th to October 10th. Which October 10th is when the Supreme Court is actually going to hear the case. If you follow on Twitter hashtag Fisher or hashtag Fisher SOTUS, as well as diversity, you'll find different tweets that BLSA members as well as the BLSA organization has posted about this case and what they're doing, as well as they're having a rally at the Supreme Court during the October 10th, which is today, Supreme Court hearing.
That's all for this week. For more contact information or any other information about this case, you can go to BLSA's website, which should be below in the description of this video or on the blog post or wherever you're happening to find this. What else can they find at the BLSA website, though?
The BLSA website will speak about the different rallies that are happening in D.C., as well as the different stances on the University of Texas case and BLSA's stance on it.
If you need, also, if there are any other student organizations who would like to do a special update, just like BLSA has, please get in contact with me, and we'll see you next time.